Chapter 34, Equity Pleading, Rules of Pleading, Sec. 212 of Pleading in General. In the introductory or first chapter of this volume some general discussion and comment on the science of pleading is found. The various steps in the action at law and in equity have been outlined, and the general rules of pleading applicable to common law actions have been touched upon. It remains now only to point out any distinctive features specially pertaining to suits in equity. There have always been persons in every generation, who may not know whereof they speak, or who have learned barely enough to make them believe themselves competent critics of a system of procedure. There have always been persons who regard the system of pleading as one invented for the purpose of evasion, or the perversion of justice. The object of every system of pleading must be to ascertain the question or point in controversy, for the action of the tribunal before whom the decision is to be made. The fundamentals of the English system of law and equity, shorn of its fictions and formalities, as it is found merged in the Reformed Code of Civil Procedure, is admirably calculated to divest the subject of a cause for adjudication of all extrinsic and unnecessary matter and narrow down the pleadings to a single point. It is a logical process, the object of which is truth, and it should be the aim of every person entrusted with the duty and function of using it for practical purposes, to fit himself by education and refinement, so that he will not misuse it, or disdain to use it for any other than its true purpose. It is an instrument of truth and justice, and not of chicanery and fraud. A careful perusal of the history of procedure will readily disclose that the fundamentals of the present code system had their origin many years ago, and are designed to carry out the principles of the speedy administration of justice, and that it does indeed embody the things popularly clamored for. In these days of clamor for reform, the hand of innovation should touch lightly a system which is the most perfect that the human mind has been able to devise. The reform that is needed is in the education, refinement, culture and courage of bench and bar, in order to rescue our system from undeserved obloquy, which may unfortunately be countenanced by instances of miscarriages of justice upon small and trivial niceties in pleading and procedure. The law of pleading is technical and arbitrary. The accumulated wisdom of years of experience have enabled the courts, statesmen and eminent jurists to devise certain rules and formulae which long experience has taught to be the best adapted to the purpose of arriving at a speedy and just decision. One will not appreciate this so well except by tracing the historical lines of the subject, in the light of varied experience and considerable research, and he will be brought to realize how venerable some of the supposedly modern reformed rules are. The rules of both law and equity have been established for the purpose of facilitating the process of investigating the truth by courts of justice. The form, mode and manner of proceedings may vary to some extent, but the most uniformed fault finder will readily perceive that there must be some form, mode and manner, of conducting the process of investigation, and he ought to know that that mode is undoubtedly the best which answers the purpose of eliciting the truth, and is the most plain and simple. It is not expected that these technical rules and forms should always be susceptible of a full justification by the reason of them being clearly apparent. The inexperienced person may conclude that some of the technical rules tend to restrain and impede the development of truth. But that is not so. They are intended to promote order and method, and work out the very best results in the hands of educated and skilled jurists. But when trusted to the manipulation of the uneducated and unskilled, there may result many departures from approved rules and formulae, which must occasion not only great inconvenience, but many times maladministration of justice. That the rules and formulae found in the Reformed Code of Civil Procedure from the merger of the old systems is the best that have ever been devised cannot be successfully denied. Sec. 213. Of the statement of the injury and right. In the statement of an injury and an application for redress, the nature of the wrong and how to set it out must first be considered. Wrongs convey an idea merely negative, as being nothing but a privation of a right. In complaining of the wrong, the plaintiff merely sets forth the facts which disclose a right. Rights rest on legal or equitable relations. In the consideration of relations, those arising from contract are generally the foundation of cases in equity. The statement of the injury involves the statement of the relation between the parties, the right accruing therefrom, and that it is withheld. The right is made to appear from statute, from precedent, or by analogy from analogous cases, or from the universal principles of equity itself. If the right is not dependent upon positive law or precedent, then it is to be established by a process of reasoning based upon the moral principles of equity. Sec. 214 of Pleading in Equity, and its analogy to common law. There is indeed a close analogy between pleading in equity and at common law. The analogy is not confined to pleading, but applies to the construction of all contracts, to all relative rights and duties embraced in the legal or equitable obligations of persons. The student will find no essential difference in the principle or rule of conduct applied in the administration of justice in the two tribunals. He will only observe it in the mode and form of the remedy. One of the objects of a bill in equity is to obtain discovery upon oath from the defendant, and to have a relief grounded on his admissions. The bill must, therefore, be framed with considerable amplitude, stating a variety of circumstances, and usually anticipates and controverts the defense of the adversary. In this respect it differs from the declaration at common law, which is a pure pleading, confined to a single and simple point of charge, or statement of injury. The answer to a bill has a double character of a pleading and a proof, being a plea so far as it denies the allegations of the bill, perfectly analogous to the general issue at law, and a proof so far as it contains admissions of any part of the bill. The invariable rule of law was that every defense which could not be specially pleaded could be given under the general issue. A similar rule holds in equity, for whenever the party has a defense, which is not the proper subject of a plea, such defense could be stated in the answer. At law a defendant was permitted to plead as many several matters to the declaration as he may wish. But only one plea to the same matter was allowed in equity. A plea could only state a single fact, or facts conducing to one point. In equity a defendant may not plead several pleas in bar, there being no necessity for it, as he may put in by way of answer the same matter. The several rules of pleading so admirably set forth by Stephen and found at another place in this volume are alike applicable to the pleadings in equity, their elements and principles being adopted and applied in equity. Pleadings in equity terminate with the replication, whereas they may proceed to the rebutter or srobutter at law. The pleading must be certain, and the matters and allegations in the bill must be consistent with each other, and must justify the relief sought. Inconsistent or alternative statements will, in general, render the bill demurrable. The rule as to ambiguous pleading is the same in equity and at law. So as to argumentative pleading, legal effect, and so on. Multifariousness in equity pleading is analogous to misjoinder, and is the improper joinder in the same bill, of several distinct, independent claims for equitable. The fault may arise from either the misjoinder of causes of action, misjoinder of parties' complaint, and misjoinder of parties' defendant.